Welcome to Property Law 101. I'm Sara Bronin, and I created the series to help you understand the basics of property law. We cover 4 fundamental questions in this series, and today we are talking about the third, using property, and about how zoning, which is local regulation of property into uses, structures, and lots, through the assignment of lots into distinctly regulated districts. Another video in this series illuminates what zoning is and what it does. One of the things that I mentioned in that video is that there are many flexibility devices in zoning. So flexibility, that's what our topic for today. So modern zoning is a combination of a fixed base map and a pattern of deal making that changes the effect of the map. We might know that or think that zoning doesn't change over time. And if you looked at the zoning codes and zoning map, that would bear out. But we've created a system which allows for many, many different allowances or exceptions in the zoning law itself. So I'm going to tell you about 6 today. First, rezonings, which are actual revisions to the text or the map. A property owner can petition the legislative body, or in Connecticut, the Planning and Zoning Commission, for a rezoning. She can ask the body to put her property in a different zone or to change the way the particular use is regulated. Some states allow for cities and developers to make deals during the rezoning process to engage in what we call contract zoning. So some say this is a good idea because it enables engagement. Others say it's a terrible idea because it opens the door to backroom and potentially shady deals between developers and politicians. So some states allow contract zoning, some don't. Second type of flexibility device is variances, which waive applications of specific provisions of the zoning code or the zoning map. These should only be granted to a property owner that shows hardship. Another video focuses exclusively on variances. Third flexibility device is special exceptions called conditional uses or special permits. These are unusual or impactful uses which can be located in certain zones but require special review. So property owners just have to meet the conditions and they will get approved. If the zoning board adheres to zoning rules in evaluating the project, then the court will uphold the decision. Fourth device, overlay zoning, which is creating a layer that goes over an existing zone. An overlay zone can override some of the characteristics of the underlying zone. I'll give you a couple of examples. So one, an aquifer protection overlay zone. That might prohibit new construction, even if the underlying zone allows it. Another example, an affordable housing overlay zone might result in new housing in the overlay district to be affordable, while the underlay does not have that requirement. Fifth, incentive zoning. These are written into the rules and give property owners bonuses for doing something that the locality wants. One type of incentive zoning is the density bonus. It allows someone to build higher or cover more of a lot in exchange for providing an amenity like a public park or affordable housing. These exist in many zoning codes, but it's debatable whether they have been effective. Sixth, planned unit developments. So these kinds of flexibility devices typically allow large lots to be developed more densely for housing than the zoning code otherwise allows. These are typically articulated in the zoning code as floating zones, which land on a property when a property owner petitions and successfully undergoes a rezoning process. So these are typically initiated by developers of large subdivisions. Add to these flexibility devices in your mind prior non-conforming uses or structures or lots, which we discuss in another video. So stepping back, you might be thinking, wow, there are lots of ways to deviate from a zoning code. Why do we have zoning codes at all? I'd encourage you to think about it in a little bit of a different way. Why do we want zoning, but nonetheless want deviations to be possible? Zoning codes tend to be highly stagnant. They change pretty rarely, and they primarily change in response to exogenous forces like state legislation or lawsuits. So these 6 flexibility tools and others provide a level of flexibility to otherwise stagnant codes. These devices also account for changed conditions, including changing demographics, market demand, or even physical geography. With climate change, for example, we're seeing greater demand for flexibility in zoning from coastal communities that are being subjected to sea level rise. From the local government's perspective, flexibility devices can also be good in that they provide an opportunity for communities to get something from property owners or from developers. In some cases, these developer concessions take the form of exactions, which are covered in another video in this series. What we talk about in that video are situations where local governments have demanded too much from developers, such that they violate federal or state constitutional provisions on takings. So, summary here, flexibility devices are not all good, they are not all bad. In my opinion, one of their biggest flaws is that they are invisible. The zoning map cannot tell you where most of these arrangements have been used, with the exception of rezonings and planned unit developments, which appear on the map. Otherwise, records of commission meetings, which may or may not be well kept, are the only way that can tell you where these individualized decisions have been made. So they are somewhat difficult to study, which for me as a scholar makes them a very curious thing. So with that, I'll leave it there. I'd love to hear from you, whether on Twitter or through my mailing list. You could sign up on my website. And with that, I will see you next time.